Hi, I'm Claudia Brown Coulter with Pivotal Peace, your go-to mediator for navigating divorce while parenting children with special needs. I'm also a registered legal document assistant, LDA, based in the greater Los Angeles area. We have to talk about service. What happens after you serve your spouse? There are various different ways to complete service. The one way you can't complete service is by giving your spouse papers. You are a party to the divorce. You cannot serve them. However, an adult over the age of 18 can serve your spouse. It's really not a good idea to use your grown children to serve the other parent or their step parent. That's tacky. But you can have a friend do it. You can also hire a sheriff to do it. You can have a process server do it, or you can have me do it. One of the things I do as part of my services as a registered legal document assistant is I serve the other party, and I serve them through the mail so that it is discreet. However, they know it's coming. It's not a surprise. It's not like, oh, what's this package? I had no idea. You want a divorce? That's not how I work. They know it's coming. They've already seen the paperwork. This is a formality. And they sign and date the Notice of Acknowledgement of Receipt, the FL-117, saying they have the paperwork. Doesn't mean that they agree with everything that's in it, but they have gotten the paperwork. They send it back to me. That gets filed with the court, and service is complete. Now, what happens in that service date is a magical date. It serves two purposes. One, it starts the clock on the 6-month waiting period in divorce, in the 6-month waiting period in California to finalize your divorce. And two, your spouse has 30 days to file a response from when they were served. What happens if they don't file a response? Your spouse does not have to file a response. If you file for divorce, depending on the county, it's about $435 in the state of California to file for divorce. If your spouse chooses to file a response, they also have to pay $435 to file that response. But if you and your spouse are working together and you are committed to staying out of court, which a lot of people are, and a lot of people never have to go to court, then your spouse does not have to file a response and you can keep working through your divorce. And you complete your divorce. It's called a default with an agreement. If your spouse is like, I really need to go ahead and get this paperwork, I need to file a response because I'm not sure if we can actually stay out of court. And if we can't stay out of court, I want to have standing so that I can talk to a judge. I can plead my case before a judge. That is a really good reason to file a response. The other reason to file a response, I do know some people who, this is why they file a response. They don't want to wait 30 days. Because this is what they can do. They can file for divorce and in the divorce filing complete their step 1 and step 2 paperwork and get that filed. They serve their spouse. Their spouse files a response and their step 2 paperwork. There's no longer a 30-day waiting period for you and your spouse to document your agreement. Before that 30 days are up, you guys can go ahead and finalize your agreement and get that filed with the court before 30 days are up so that you can get that process going of finalizing your divorce. In Los Angeles County, they finalize your divorce like that. They'll still make you wait 6 months, but they'll send you the paperwork right away and they'll tell you the date in the future that your 6 months is up. For other counties in California, such as Santa Clara or Contra Costa, it could take 6 to 8 months just for them to process your final paperwork. In addition to the 6 months it takes for you to get divorced in the state of California. So if you're in one of those counties, it's a really good idea if you guys are working together to get things filed as soon as possible, to have your spouse file a response and their step 2 financial disclosures and document your agreements so that you guys can get your place in line to get your agreement finalized. If your spouse does file a response and you guys make an agreement, it's called uncontested. It's the same process. You're not going before a judge. One of the things I love about California is you can agree to everything out of court and not have to go. In some states, you still have to go before a judge for a final hearing. You don't have to do that here. It's great. They don't want you there. They don't want you in their courthouse. It's great. When someone doesn't file a response, it proceeds as a default. But there's a difference between a default with an agreement and a true default. If someone's defaulting with an agreement, they're actively working with you. You guys are exchanging disclosures. You are probably in mediation. You are signing and notarizing that final document, that judgment that says this is everything we've agreed upon. It's very different than someone is evading service. They're running from the process server. You cannot find them. They move to another country. their family is hiding them, that's very different. That's a true default. You cannot find them. They are not cooperating at all. In the event of a true default type situation, you do want to get some legal advice of how do we motion and petition the court so that I can do service via publication, so that I can make sure that I amend my documents and I'm not using the FL 142, I'm using the FL 160 to document all of my separate and quasi-community and community property. Because the judge cannot rule on things that aren't written down. So the judge is going to need to see all of that documentation. So you're going to need legal advice around a true default. It doesn't really matter if your spouse responds or doesn't respond. The goal of a divorce should be a mutual parting of ways. Even if you don't want the divorce, it takes two to get married, but one to get divorced. So if your spouse doesn't want to be married to you anymore, I know how heartbreaking that is. I know. But if they don't want to be married to you anymore, let them go. Do your best to stay out of court and resolve this. So don't delay things if you don't have to delay things. If you guys don't want to spend an extra $435 on filing a response, you don't necessarily have to. But keep working, work together on these agreements. The magic date is that date of service. It starts the clock ticking on your waiting period of 6 months. Don't waste that time. Get your paperwork in well before the 6 months is over, because there could be a delay if the court changes their rules. Sometimes there's picky clerks and they reject things like the county next door didn't reject this. Like, what? You're not making any sense. They've clearly agreed to these things. Like, who knows? So you want to have things in so there are not future delays. Other times people make mistakes and then they get mad. Well, we have to get this done in 6 months. It can take longer than 6 months. Nothing bad is going to happen, except you're going to still be married to them if it takes longer than 6 months. You want to do your best to get as much stuff done as quickly as possible. There is this great feeling when you know, I still got to wait 6 months, but the paperwork's in and I'm done. All the negotiations are done. All the conversations are done. I'm just waiting on the clock now. That's a good place to be. Service doesn't have to be scary, but really the best type of service happens when you're communicating with your spouse. It is not a surprise. They are not being blindsided. They know what is happening. They're in the loop and you guys are working together. It is possible. It can happen for you. If you found this video helpful, please like and subscribe. And if you know someone who could use this video, please be a good friend and share it with them. Have a good week.